Hello everyone, and thanks for joining us for today's webinar, Mental Health in the Workplace, the Duty and Benefits of Accommodating Employees with Disabilities. My name is Laura Mullally, and I'm a Program Manager in Prevention and Promotion at the Mental Health Commission of Canada. I'm very happy to be hosting this webinar with you today. Just before we get started, I want to go through a few housekeeping items about this Adobe Connect platform. The audio is provided to you in broadcast mode only through your computer speakers, so you can hear us, but we cannot hear you. This webinar is being recorded and will be posted on the Mental Health Commission of Canada's website in our webinar archive section in the next few weeks. If you would like a copy of today's slide deck, you can download it right now using the Files pod in the middle of your screen. Just select the item you want to download and then click Download Files. I invite you to send any questions using the Q&A pod, which can be found on the bottom right of your screen. Questions posted in this pod will go directly to the host, and we will hold most of the questions until the end of the webinar, and then we'll address them in kind of a verbal Q&A fashion. If you'd like to interact with other webinar attendees or post any comments, please do so in the chat pod on the top right of your screen. Just a kind reminder that the comments made in this public chat box will be shown to everyone with your name associated with it. So I'd like to just take a brief moment before we get started to introduce Civic Action, who has played an integral role of putting together today's webinar. For over a decade, Civic Action has brought together the Toronto region's rising and established leaders to tackle some of the most pressing urban challenges, such as youth unemployment, carbon reduction, transportation, and many others. In recent years, mental health has increasingly become recognized as a pressing urban challenge. In response, Civic Action tapped into the strong leadership it has with many organizations in the region to help move the needle on this important issue, and together launched a Mental Health in the Workplace program a year or so ago called Minds Matter. The Mental Health Commission of Canada is one of over 35 organizations that have supported Civic Action in the creation and delivery of the Minds Matter program, including the development of the Minds Matter assessment tool, which you'll hear about a little bit later on in this webinar. We're also working together to support Minds Matter participants and others like yourselves in creating more supportive workplaces with learning opportunities such as today. So without further ado, I'm pleased to introduce our esteemed panel of presenters today. So we're joined by three guests who are going to talk about the duty and benefits of accommodating employees with disabilities in the workplace. Firstly, we're joined by Muniza Sheikh, who's a partner at Levitt LLP and practices in the area of labor and employment law. She provides advice and representation in employment matters to corporations and executives, including dismissal, hiring, contracts, human rights, and employment litigation. Muniza works closely with her employer clients to ensure their policies relating to employment law and human rights are enforced and applied throughout the workplace in a manner that's efficient and consistent, and conducts a number of management and HR workshops to help keep employers apprised of their obligations and that they're under the current employment legislative scheme. Joined by Muniza is Sal Cavarici, who's the director of the Mental Stress Injuries Program at the Workplace Safety and Insurance Board, Wsib. During his career at Wsib, he's held a variety of roles, including Appeals Resolution Officer and Policy Analyst. Sal holds a Bachelor of Arts and a Master's in Public Administration degrees. And finally, Jenny Winter is the Vice President of Human Resources for CGI Canada. Jenny is helping to accelerate CGI's growth through leadership, differentiated talent models, attracting and developing the best talent, and building a culture of engagement, agility, and innovation. Over the past 2 years at CGI, Jenny has developed a high-performing HR team consulting leading change and enabling a great environment for its members. Jenny has led HR for several acquisitions from due diligence through the integration that retains value and enables success. Under Jenny's leadership, CGI has been recognized as a top employer in Canada for the past 2 years. Jenny is passionate about creating an environment that enables its employees to achieve great outcomes. So welcome, everyone. We're really looking forward to hearing these three different perspectives on this webinar today. So Muniza, you're going to get us started, so I'll pass it over to you to get this webinar going.
Wonderful. Thank you so much. Good afternoon, everybody. So as was mentioned just a little bit earlier, I practice in labor, employment, and human rights. And so my discussion with respect to mental health in the workplace is largely going to speak within the next 15 minutes, although I'll certainly get an opportunity to address any questions that some of you folks may have, an employer's obligation and also certain obligations that employees may have as well. Just bear with me while I move to my next slide here. So the two aspects I'm really going to be looking at is the duty to accommodate and the benefits of accommodation. So one of the questions that you may ask yourself is, why does mental health in the workplace matter now? And why is it such a significant issue right now? The emerging trend when looking at the discussion around mental health in the workplace as it relates to discussions when looking at the Human Rights Tribunal, the courts, and through arbitration, both in the unionized and in the non-unionized context, is that employers need to take active steps to both address and promote mental health and reduce the stigma of mental illness in a workplace setting. In short, employers have a very important role to play here. And so what we've seen for many years, and again, speaking from the employment practice and speaking from the perspective of the person who obviously practices in this area and advises in this area, the obligation for the person suffering with any issues in relation to mental health as far as it relates to a disability, that obligation is not on the employee. Of course, they have an obligation to, accommodate, cooperate in their own accommodation. But again, there's this widespread recognition now from the legal perspective that there is a significant amount of responsibility on the employer to take steps to ensure that any stigma as far as it relates to mental health in the workplace, they're taking steps to alleviate those issues. As a result, in my practice, and my practice largely is my frame of reference, a number of my clients, my employer clients, some of who I see are actually logged in to this webinar, so happy to see some familiar names. So as a result in my practice, a number of my clients, and in some cases they're doing it preemptively, are reaching out to ask questions with respect to how do we train our HR departments on how to deal with health accommodations? Is there a particular sensitivity around mental health accommodations? And that really means providing education. And in my role, much like what I'm going to do with this group today, my goal, of course, is to provide HR with a sense of its legal obligations as it relates to employees asking for an accommodation in the workplace. I've seen a few people have noted they're having a little bit of difficulty speaking, hearing me, so I am going to try to speak up a little bit, so I hope this is helpful. So what I'm really going to look at first with respect to duty to accommodate is the code, the accommodation, this concept of undue hardship, and BFOR, which, sorry, just bear with me for 1 second here. I seem to be having a slide malfunction. And so in my discussion today, and in large part because Sal is going to be touching on some of the areas with respect to WSIB, the focus of my discussion, of course, is going to be around the Ontario Human Rights Code. And for the most part, much of the principles that I'm going to discuss are relevant when looking at the federal code and other provincial human rights legislation as well. So as you may know, when looking at the Human Rights Tribunal, well, the tribunal is certainly best equipped to deal with violations under the code, violations of the code as it relates to our discussions today. So an instance where an employee states that an employer has failed to accommodate their mental health as a disability under the code can also be dealt with in private arbitration, both inside and outside the unionized context, and can also be dealt with in the civil courts. So when looking at the language of the code specifically, the Ontario Human Rights Code ensures that equal rights and opportunities, freedom from discrimination, the dignity and the worth of every single person with respect to an accommodation, individual arrangements involving needs to be linked to the disability beliefs and practices related to a person's creed or religion, family responsibilities, or gender, so employees can do their jobs, access services and buildings, and enjoy housing equally. So accommodations can be based on any code ground, but in a disability employment context, the duty requires adjusting working conditions so that people can continue to work when they are grounds that make it difficult for them without an accommodation. What you should also understand, of course, is that when looking at the duty to accommodate, there's also an obligation on the part of the employee that is requesting the accommodation to cooperate in their own accommodation issue. That means giving the employer the information that they need in order to satisfy their obligations under the code. So this might be quite obvious, but I can't tell you how many times in my practice there is this understanding, and this is where I represent employees, because I do have a small plaintiff practice as well, where there's this, there's this view that if you ask your employer for an accommodation, that really doesn't trigger any obligations on the employee's part, which is absolutely false. While generally an employer is never entitled at law to your diagnosis, they are entitled to the employee's prognosis to the extent that it would provide assistance in the accommodation. In my practice, what I see, unfortunately, is two extremes. So on some hand, in some respects, with respect to some of my employer clients, I see clients asking for overly expansive and sometimes invasive medical information under the guise of a duty to accommodate. And then on the other end of the extreme with employees, sometimes I do see that employees are under the false impression that they have to provide very little or no information in requesting an accommodation in the workplace. And both are problematic, and both, I would say, erode the integrity of what the intentions are when looking at the legislation in this area. So when looking at the principles of accommodation, really, and of course you folks can all read the slides, the principles of accommodation look at three main factors. They look to preserve a person's dignity. They look at this concept of individualization and, of course, inclusion. And I always say inclusion is the most critical because essentially what you want to do is you want to create a workplace that integrates and has full participation, is barrier-free when looking at individuals who may have issues. And sometimes these issues are permanent, and sometimes these issues are temporary as far as they may relate to mental health. And again, you want to send a very strong message to the rest of your workforce that, you shouldn't feel demoralized if you have any sort of issues with, or if you have any sort of health issues, and you should feel comfortable coming forward. The most appropriate accommodation must be identified and implemented short of this concept of undue hardship, which I am going to get into. Deciding what is and what is not an appropriate accommodation, it's a separate analysis from an undue hardship analysis. An accommodation will be considered appropriate in most cases if it's going to result in equal opportunity to attain the same level of performance or to enjoy the same level of benefits and privileges that are experienced by others, or if it's proposed or adopted to achieve opportunity and if it meets the individual's needs related to the relevant code ground. The most appropriate accommodation will be the one that most promotes inclusion and full participation and effectively addresses any systematic issues. For most employers, and again, in my experience, it's usually the smaller employers who may have more of a challenge. They may not have many positions available to the requesting employee, and this can sometimes, of course, pose a challenge when trying to accommodate that employee. So, when looking at accommodation, it could require a modification of duties, it could require providing assistance or other support, or in some cases, allowing some time off to address the needs based on code grounds. Now, when looking at this, when looking at my frame of reference, which is my practice, what I see more often than not in relation to mental health issues in the workplace, usually, and of course this is not always the case, but usually it's about allowing time off to address some of the needs based on the code grounds. So, where someone raises an issue, usually it raises an issue with respect to mental health. Usually it's more about job protection. And so in my practice, that's where I find I usually give the most substantive advice to my clients. So if we're looking at an employee's responsibilities, the employee's responsibilities will look, of course, at requesting the accommodation, explaining, why the accommodation is required, so the needs are well known. It's best to put a lot of this in writing, I usually say, and it's good for the employee, but it's also good for the employer as well. And take part in discussions where you can talk about possible accommodation solutions that might be required. If a less expansive or less disruptive option is considered, it might still meet the employee's needs. And after the accommodation is in place, the person must be capable of carrying out essential duties or meet essential requirements. So if a person's entitlements must end. However, there may be an obligation to provide alternative work depending on the specific circumstances. In employment, the duty to accommodate requires adjusting working conditions so that people can continue to work when there are code grounds that might make it difficult for them to work. Again, in my practice, it's usually the bulk of the questions from the employer are usually around, well, what are our obligations to provide a job protective leave so the employee can take time off to get well? Again, while that's certainly not the only accommodation, job protective leave is a accommodation that is necessary when looking at mental health. And again, that's largely the discussion that I deal with. What I'd like to do now, if I can, is look at an employer's responsibilities. So an employer's responsibilities in this context is to accept the employee's request for accommodation in good faith unless there are legitimate reasons for acting. So, and also to get an expert opinion where it's needed. So many claims of discrimination arise from an employer cutting short on an accommodation process because this perception that there's an employee is not filling his or her requirements. So oftentimes I have employers reach out to me and say, well, I have a certain employee who is requesting an accommodation. They're, essentially taking the position that there's some sort of mental health issue. And, we're of the view that, we don't necessarily think that this is something that we should be accommodating. And again, that from a legal standpoint, there is no basis for an employer to take that position without first ascertaining whether or not there can be an accommodation. So more often than not, I see a lot of clients who are simply taking the position that, look, I'm not necessarily sure that this is something that we need to understand, that we need to undertake. And my advice to them is, look, from a legal standpoint, you need to make the appropriate inquiries. While there certainly is no legal obligation to accept a blanket doctor's note that might say that, there's a mental health issue at play, you are certainly allowed to turn to the employer and say, look, employee, that we're not entitled to your diagnosis. However, we do want to get a sense of what sort of accommodation you require, how long you expect to be off, and most importantly, what it is about your prognosis and what it is about, essentially what is it about your condition that precludes you from being able to perform the essential duties of your job. So these are really the questions that you should be asking when looking at what an employer's responsibility is. What I wanted to do as well, and what I will do is given some of the issues that we're dealing with in time, is you'll all have an opportunity to look at the cases and look at the slides, of course, but I was hoping that I could discuss with you an issue that I'm dealing with in my practice right now. So I'm dealing with a police services case right now, and the employee that I represent is had raised mental health concerns with her employer a couple of years ago, and the response essentially was that we don't believe that you're sick, and because she was a unionized employee, there was an obligation to have her undergo an independent medical examination. And what the employer essentially did is they had her undergo the independent medical examination and then on a unilateral and arbitrary basis did not accept those findings, unfortunately. And now we're essentially dealing with the issue before the Human Rights Tribunal. So even though this particular employee is unionized, because her union didn't deal with the mental health issues and didn't file a grievance on her behalf, we're now going through the very lengthy process of filing a human rights complaint, and it's a 19-day hearing that's set before the tribunal that's set to be heard this year. And the main issue that we're dealing with is why the employer decided to unilaterally take the position that the IME was not sufficient. So I see that I have run out of time. Again, you folks are more than welcome to go through my slides in detail, and I hope that I'll have an opportunity to answer some of your questions during the question and answer period at the end.
Thank you very much, Muniza. That was a great presentation. And as you mentioned, the slide deck is available for download. Under the Files pod in the middle of your screen, you can see all of the rest of the content, including some additional examples of case law that Manuza has provided. So thank you very much for that. And we've gotten some really interesting questions coming through. We're going to hold the questions to the end of the presentation. So next we're going to allow Sal to go ahead with his presentation, and then we'll address the questions at the end.
So thanks and good afternoon, everybody. And Manuza, thanks for that presentation. Where I will come in is really to speak about workplace and related events. So I would like to thank the Mental Health Commission of Canada and Civic Action for the opportunity to participate in today's webinar. I'm also joined by Sue Timlin, the Director of our Return to Work program here at Wsib, and she's available to answer questions when we get to the Q&A section. Over the next few minutes, I will provide a brief overview of recent legislative and policy changes in Ontario pertaining to mental stress injuries, how we manage these cases, and some of the benefits and services that are available. Now, I understand our audience includes individuals from across Canada, and I thought it might be helpful to provide very briefly an outline of who we are as WSIB and what we do. So WSIB, or Workplace Safety and Insurance Board, is an independent trust agency of the Government of Ontario that administers no-fault workplace insurance for approximately 300,000 employers and covers more than 5 million people in the province. We provide disability benefits for people injured at work and benefits for the survivors of people fatally injured in the workplace. We manage the provision of high-quality health care, and we also assist in early and safe return to work for people who are injured on the job or who contract an occupational disease. Now, workers' compensation legislation is a provincial matter, so each province and territory has its own legislative framework and agency for dealing with such issues. So my comments are specific to Ontario, but I will attempt to provide appropriate cross-references to other jurisdictional issues as appropriate. So in this slide, I really want to show or provide a quick overview of the legislative history in Ontario as it relates to mental stress injuries. So Ontario has been compensating for work-related traumatic mental stress since January 1998. While the WSIB has always compensated for psychological conditions that were a sequelae to a physical injury, this was the first time we had specific legislative provisions relating to mental stress resulting from what was known at the time as an acute reaction to a sudden and unexpected traumatic event. So essentially an injury in the absence of a physical injury. In April 6, 2016, our Act, the Workplace Safety and Insurance Act, was amended to allow for presumptive entitlement for first responders and other designated workers diagnosed with post-traumatic stress disorder, and this was a first as well. Now, more recently, and the focus of today's conversation is really the amendments that occurred as of 2017. So as of January 1st, our Act was again amended, and the provisions related to traumatic mental stress were altered by eliminating the requirements for an acute reaction and the requirement that the traumatic event be sudden and unexpected. In addition, the Act was also amended to allow us to compensate for work-related chronic mental stress. Now, in the interest of time, I will only provide a brief overview of the presumptive legislation for first responders. For this presumption to apply, the person must have been employed as a first responder or other designated worker for at least 1 day on or after April 6, 2014. You will note on this slide that there are 12 categories of occupation that are covered under this presumption, ranging from police officers, paramedics, firefighters, and through to correctional officers. Now, the diagnosis must be post-traumatic stress disorder as diagnosed under the Diagnostic and Statistical Manual of Mental Disorders, or the DSM. And that diagnosis must be provided by a psychologist or psychiatrist. Now, the presumption does include provisions for rebuttals if it is established that the employment was not a significant contributing factor in causing the PTSD. The entitlement for PTSD that is a result of an employer's decisions or actions that are part of the employment function are also excluded from the presumptive coverage. Now, in addition to Ontario, I understand that Manitoba, Alberta, and Saskatchewan also have various forms of presumptive legislation for post-traumatic stress disorder. Now, but the specific requirements do vary from province to province. Now, under the traumatic mental stress policy, a person will be entitled to benefits if an appropriately diagnosed injury is caused by one or more traumatic events arising out of and in the course of employment. That is, the event happened because of work while the person was at work. Now, objectively traumatic events may be a result of a criminal act or a horrific accident. It could involve actual or threatened death or serious harm against the worker, co-worker, or worker's family members, and it can be sudden and unexpected in many cases. This policy also allows for the consideration of the cumulative effect of trauma. And again, from a jurisdictional standpoint, many of the provincial and territorial authorities dealing with workers' compensation have legislation that addresses traumatic stress, and this includes British Columbia, New Brunswick, Newfoundland, Northwest Territories and Nunavut, Nova Scotia, Prince Edward Island, and the Yukon. Now, this slide is provided more as a reference to the audience, as I will not be going into significant detail, other than to note that this new policy, the amended policy, is effective for accidents on or after January 1st, 2018, and transitional rules were provided to address cases that were in effect prior to January 1st, 2018. So now to talk about the chronic mental stress policy. So here, a person will generally be entitled to benefits for chronic mental stress if an appropriately diagnosed mental stress injury is caused by a substantial work-related stressor, and that really is the key issue arising out of in the course of employment. Again, so the event happened because of work while the person was at work, and substantial work-related stressors could include workplace bullying and harassment, and in that regard, the definitions are consistent with the Ontario Occupational Health and Safety Act. There are three key policy requirements in determining whether a condition is work-related. So there must be a DSM diagnosis from a family doctor, nurse practitioner, psychologist, or psychiatrist. And this requirement really allows us to confirm that there's a recognized disorder. There must also be evidence of a substantial work-related stressor. So the policy notes that a stressor may be substantial if it is excessive in intensity or duration in comparison to the normal pressures and tensions experienced by workers in similar circumstances. And this requirement really speaks to the injuring process. And finally, the decision maker must, on a balance of probabilities, be satisfied that the substantial work-related stressor was the predominant or main or strongest cause of that person's chronic mental stress for there to be entitlement. Now, as with the other policies I've mentioned, conditions that are a result of an employer's decisions or actions are excluded unless those actions reach a level of harassment or conduct that would be perceived as either egregious or abusive. Now, this new policy took effect January 1st, 2018, and applies for all accidents on or after January 1st, 2018. This legislation also included some transitional provisions so that if a person had a mental stress condition with an accident date on or after April 29, 2014, and had not yet filed a claim with the WSIB, that person could file a claim with WSIB provided that we receive it on or before July 1st, 2018. Also, if a person has a claim for a mental stress condition that is pending a final decision by the WSIB or the Workplace Safety and Insurance Appeals Tribunal as of January 1st, 2018, that case would come back to the WSIB to review and apply the new policy. Now, in terms of other jurisdictions, in addition to Ontario, British Columbia and Alberta have legislation dealing with chronic mental stress, and they follow a similar predominant causation test. I understand Saskatchewan and Quebec also have legislation related to chronic mental stress. So that's the legislative and policy framework, but I wanted to speak a bit about what do we actually do with these cases when they're received and how do we manage them going forward. So the Mental Stress Injuries Program has been in existence in various forms at WSIB over the last 15 years or more. Our commitment in all of the mental stress injury cases is to provide quality services to support timely decision-making, and in cases that are allowed, support for recovery and return to work. So as a program, we are responsible for the entire management of the case from the initial determination of entitlement through to the resolution or closure of the case. And as you'll notice in the slide, we work in an integrated fashion with our case managers, our nurse consultants, the managers, and our specialized work transition specialists. So the overall focus of our service delivery model is, as I said, to render timely decisions, and in those cases that are allowed, to provide support for the person's recovery and eventual return to work. Our triage approach ensures that we assess new cases quickly with a view to moving cases to the right individual as soon as possible for ongoing case management and support. We also recognize that different cases and individuals will require different supports and services. So we have one case stream for individuals who are at work already or are ready to return to work or are in the planning process to return to work. And we have another case stream for individuals who may require significant recovery interventions. We also facilitate psychological assessments and treatment, and this includes coverage for medication to support individuals in their recovery. So as of this year, we've created a new reporting form for family physicians and nurse practitioners to support the reporting of occupational mental stress injuries. So once a patient indicates that they have a mental stress injury or believe it is work-related, there's a particular form that allows us to capture the right information by the treating practitioner. We also have a network of psychologists and psychiatrists that are available to provide timely assessment and treatment for first responders. In 2018, Wsib launched the Community Mental Health Program in partnership with the Ontario Psychological Association, which has also provided a further network of community-based psychologists that are available to provide timely assessments and treatment of individuals with an allowed mental stress injury claim. And finally, through our specialty clinic program, we also have access to the psychological trauma program at the Centre for Addiction and Mental Health in Toronto, which again can provide expedited multidisciplinary assessments. And finally, and certainly not least, when psychologically supported, we also have and engage our work transition specialists to work with the person, the employer, and the treating practitioner in facilitating a return to decent, safe, and sustainable employment. So that's a very abbreviated view in my 15-minute segment to outline the policy and legislative framework for work-related issues, the types of benefits and services that are very specific to WSIB in Ontario. I haven't really gone into the wage loss benefits and things like that, but specific to psychological or mental stress injuries. So for more information, the listeners may wish to look at our website, www.wsib.on.ca. And on that note, I will turn it over to Jenny.
Hi, everyone. Thank you, Sal. It is a true pleasure to be with you all today. So I would say good morning and good afternoon. I understand that we have folks from across the country. I'll start with just a very quick introduction to CGI for those of you that may not know us. So CGI is a technology consulting organization that started in Quebec. And currently in Canada, we have about 11,000 employees, and we are coast to coast. So we have an office in Victoria and then all the way to Halifax. The company is about 40 years old, and at this point, we are in over 40 countries and have about 75,000 employees in total. So it's a fairly big organization. And wellness is a core part of our offerings for our members. And I'm happy today to share a little bit about how we approach mental health and the responsibility around accommodation. So our wellness function at CGI is actually called Oxygen, and there is an Oxygen function in every country that we work in, particularly in Canada, which is where my focus is. We have a very strong team and have 10 people dedicated to helping us look at what we need to do around people's health and wellness. Mental health is a key part of that. And we look at this through the lens of 4 pillars. So we look at education and awareness, the risk, making sure our leaders are prepared, and that employees that need the support have it. So I'll just quickly walk you through a little bit and highlight some of the things that are on the slide. I won't read all the words. I know that you can do that. But around education and awareness, our approach is that this is continuous. So we don't pick a time of year and do a big campaign, but our approach is that this is ongoing. We look at awareness coming through our internal website, our portals, but also in our offices, making sure that there's very visible, tangible communications around this. We also have lots of lunch and learns and training sessions. Up here, one of the things that you'll see highlighted is Resiliency Training. And we will do that, open it up broadly, but we also do that when we have, we do a lot of mergers and acquisitions and big deals. So if we have teams that it's particularly stressful, that they're under quite tight timelines, we will offer up specialized training for project teams to help support them through those particularly busy times. And we look at, when we talk about education awareness, we've called out here financial health, but we look at all that can impact mental health and making sure that we talk about physical health, mental health, financial health is also important, so all those aspects. Around risk, and so we do have a very strong online site, a portal that we've built that is globally available for our employees, and that this is completely optional, it's voluntary, but people can go through and assess any health risks they may have. And there are questions tied to mental health. And so the idea being is that if you need help, that you can see that, but also then know where to go for it. And so we've got lots of links and access to resources and information to support our members, we call our employees members. That around the leaders piece of it, so it's very important to us is that all our employees have the support they need within their teams, within the day-to-day work, and that leaders know what they need to do and how do they support their employees. So we've called out here some of the things that we do. We do have a toolkit that's made available for our leaders. Again, the resilience training we've called out. CGI 101 is our executive development program that we offer globally, and we have a specific presentation, and this is for directors and up in the company, and it is compulsory development for all our Director Plus. It's a 4-day offsite that everyone goes through, and including this section around mental health. And then the support. So we believe in supporting our employees, but also the communities that we work in. So we've captured some things here as well. Moving on and looking at our duty to accommodate and how we approach this, I could simply put without all the words that are on the slide, but it really is around collaboration, partnership, and planning. So we do look at each individual situation, each individual case, and look at what we need to do to help support that employee. We come at it from a team perspective, and so when somebody's returning to work, there is a team meeting to look at what's needed to support that person. You know, I will say that accommodation to us is not just about returning to work when someone's been off and how do we modify duties, but sometimes we need to put people in a different role, and we will look at how can we do that. Can we accommodate? What would that role look like? So that we can support them, and whether that's for an interim period or for something longer and more indefinite. But it's very important to us is that we are treating our employees with respect, with understanding, and again, that there's a real partnership to come up with the right outcome. We've included here just a little screenshot that we actually do have an online site set up to support everyone involved to ensure that successful return to work if someone has been absent. One of the things I was asked to talk about were our benefits, the benefits of the approach we take to accommodation. We've captured some things here. Obviously, it's better for our employees. The leaders are better supported. It really is a win-win. Not on the slide, but I could add, you know, much more. I think people get back to productivity faster. We get people back to health. We have less reoccurrence. We've got people feeling they're adding value and contributing, and it's a positive environment, not just for the employee, the leader, but even the rest of the team, and people are well supported. Going to just move on. So we've got at the bottom of the slide, so that actually is what was core to our company when our founder established the company in 1976. He had a vision around creating an environment where people come together to do great things. and as I mentioned a couple minutes ago, is we call our employees, we call them members, and we feel that we're all part of a team and contributing. And so whether that's someone who's in full health or someone who is working through health issues, we really do believe that we've got to work together and are committed to great outcomes together. So we've got here collaborative efforts between our stakeholders. So that's the HR business partners. We have a return to work team, which is in our benefits group. We've got total compensation who take care of our programs, our wellness team, business leaders, and then if our insurance providers needing to be involved, they're also there as well. So we do look at this proactively, and there is, of course, when necessary, a reactive approach, but we really do believe in education, risk management, training, that we can avoid some of the more complex cases that can occur. And we more and more feel we have a responsibility within the Canadian broader environment to ensure that we're helping support mental health across Canada. But also it's very important for us to participate in calls like this, and there's always learning. So I've been taking notes as I listen to the two other speakers, and it's very important to us is that we continue to stay current and ensure that we're offering the best that we can. Because we're coast to coast and we are provincially regulated, we have almost every single province that we need to look at the Employment Standards Act, the human rights legislation, and ensure that we understand our rights and requirements to support our employees. So that's it for me. So I think I've gone a little quicker than I was given time for. So hopefully that will allow some questions at the end, because I can see there's certainly been lots of questions coming in. So Leslie, I will turn that back over to you.
Great. Thank you so much, Jenny. And thank you, Sal and Manisa. Such helpful, valuable information. Before we take a few of the questions that have been put out there, we just want to take a minute or two to highlight a couple of resources that might be helpful to you folks in your organizations in creating a more mental health supportive environment. The first is the Minds Matter assessment. This assessment was developed for organizations that want to take a first or a next step in creating a more mental health supportive environment, but aren't quite sure where to start. By simply answering 12 questions in under 3 minutes, you'll be provided with 3 tailored recommended actions with corresponding resources to help with the implementation. And it's a simple tool to help you kickstart your organization's mental health journey. I'm going to turn it over to Laura now.
Thanks very much, Leslie. Also, just prior to us getting started on the question and answer period, I just want to highlight that the Mental Health Commission of Canada also has some resources available to you. If you're looking to prevent psychological harm and promote psychological health and safety in your work environment, if you're not already familiar with it, the National Standard for Psychological Health and Safety is a free resource available to you, as well as its associated implementation guide, also free to download off our website, that really walks you through the journey of kind of starting from the beginning, assessing what you have already in place, what your objectives are, what those gaps may be, and how to take action to address psychological health and safety in your work environment. So I encourage you to take a look at those if you aren't familiar with them already. So now we're going to open up for a quick question and answer period in about the 15 minutes we have left. I've really appreciated kind of the expertise that we've heard already today. We've really been brought on a bit of a journey on accommodation within the workplace, first starting with some of the facts and the law from Manisa, then Sal gave us some context from Wsib, and then Jenny really gave us a bit of a case example about how this applies in CGI. So we've kind of been walked through the process today, and there have been a lot of different questions that have come in, both through the Q&A pod and the chat. We are going to try and address as many as we can in the 15 minutes remaining. Just to highlight that we are almost over 400 people on the line, so we do have lots of questions that have come in, so we'll try our best to address what we can. So to get us started, there have been a lot of questions about kind of that duty to accommodate that you were talking about at the beginning, Muniza. One of which is kind of the time required for an employer to comply with accommodation requests. Is there a specific timeline that's set out by the law or a best practice that people should be aware of?
So it's a very good question, and there's no legislative timeline. The only standard that a vice chair or an arbitrator, or in some cases a judge, the only standard that they're going to look for an employer to apply when looking at accommodation is going to be one that is reasonable. So obviously in each individual context, you need to look at each case on a case-by-case analysis, and so the standard is always going to be one of reasonableness. So if you have an employee that is asking for an accommodation, given the type of accommodation, given the type of workplace, how long would it have taken reasonably for the employer to ascertain whether or not the accommodation would have been reasonable? Did the employer take steps to be timely and make, ask the right questions? This is all going to be something that's going to be addressed by a reasonableness standard. Now, if I may, and I appreciate that there's a number of questions, but one thing that I see recurring in the chat is this question around an IME and a medical note. So is it okay if I address that very quickly for some of the listeners?
Yeah, definitely. Thank you.
Well, thank you so much. So one of the questions was, okay, a lot of times you will get that doctor's note, and we all know, like essentially you see your family doctor and you can say to your family doctor, look, I'm not feeling so great and I want you to write a note that tells my employer that I want to be off for the next 2 weeks. So in a perfect world, your family doctor in those circumstances should say, well, you know what, I'm not necessarily comfortable writing that down on a notepad, scribbling that on a notepad without, a proper or adequate understanding of what your job is, but a lot of family doctors will do that. And then I get employers emailing me saying, hey, Muniza, look at this note that just came in, which is really just a scribble on a notepad that says employee will be off for 2 weeks, will be reassessed then. And in those circumstances, while an IME, which keep in mind is usually seen by any of trier of fact, whether we're talking about in the unionized or in the court context, to be very invasive, there are a lot of in-between. So there is no obligation for any employer to accept that sort of evasive response. So while an employer certainly can't respond by saying, well, I want to know what your diagnosis is, what I do for my employer clients is I draft a very thorough, almost like a questionnaire for the doctor, which asks basic questions like, what is the prognosis? How long do you expect it'll take the employee to be well again? What is it about their specific condition that prevents them from, being able to perform the essential core duties within their job function? So again, it definitely isn't an IME, but an employee's doctor does have an obligation to be honest. And what I usually find is, while you may get that initial, scribble on a notepad that says employee not well and, we'll reassess in 2 weeks or a month, once you present that doc, and you can put a time limit on that and say to the employee that, look, I completely understand how long it takes to get a medical opinion sometimes, so you have a week or 10 days to get back to us with respect to this questionnaire. Once they get that questionnaire, the doctors are usually far less inclined to, be so gratuitous in terms of how long it might take that employee to get better. So I hope that answers that question. I saw it come up a few times, so I hope I've answered that.
Thanks very much. And yeah, thanks for addressing that question. There's been a fair amount of chat about that in the chat pod, which is it's great to see people kind of sharing their different perspectives and thoughts on that. There was a few different questions that have come through too, also about the duty to accommodate and how that comes into the hiring process, and at what point during the hiring process should or can managers inquire about any need to accommodate, and is there any best practices around that?
So would you like me to answer that question?
Yeah, if you'd like to talk about that, that'd be excellent. Thank you.
Yes, I'm happy to do that as well. So it is a very good question. So generally speaking, there's always a significant risk when asking questions around accommodation during the interview process. So I completely understand from the perspective of the business that, you know, it's a question that you may be tempted to ask, but I would say for the most part, you know, if you're interviewing a candidate and where they have not raised an accommodation where they have not raised an accommodation issue in the interview, I would say that it carries far too much risk to address the issue in the interview yourself, because potentially if you don't end up hiring that person, and we've all seen this happen, the potential employee could file a human rights complaint and take the position that one of the reasons that there was a differential treatment within the hiring process was simply because, you know, the employee disclosed, you know, that they may have required an accommodation, or the employer raised the issue. Where, however, the employee themselves raises the issue in an interview with respect to a potential accommodation, it is entirely appropriate in those circumstances for the employer to ask some questions around what the accommodation might mean, but the same rules still apply, which means you are not entitled to the diagnosis. And I would say in those early stages, when that person is not even working for the employer, I would say you don't even ask questions about the prognosis. So a simple question such as, what type of accommodation is it that you require? That would be appropriate. But again, you know, there's a lot of risk with that sort of discussion at the interview stage as far as potential exposure to a human rights complaint. And unfortunately, I have seen that happen many times.
It's Jenny Winter, and I'm happy to also provide an answer if you like to that question.
Yes, thank you very much, Jenny.
So the way that we would approach it is that we never ask that during a recruiting process, but we do have on our website and in all our role files that we're handing out or emailing for the candidates to know what they're applying for, that we have a statement at the bottom, and it says that we're committed to providing accommodation in accordance with provincial legislation, and we say, please let us know if you require a reasonable accommodation during any aspect of the recruitment process, and we will work to address your needs. So we're really letting them know we're open, but we are not directly asking that question.
Thanks very much, Jenny, for that kind of example and perspective. Sal, just kind of linking to that, there was a question about how does a pre-existing mental health condition and diagnosis impact WSIB eligibility?
So thanks. That's a good question. When we look at pre-existing conditions, we really have to understand, first of all, is the event that occurred that the person's claiming, did it happen at work and arise from work? So that's really the first test that we look at. And then we have to assess and collect the appropriate information on the pre-existing condition to determine whether or not that had an impact on the event occurring. So it's not a simple answer as far as that goes, but first and foremost, we have to determine whether or not, if there was an event, a specific event that occurred, and then the impact of the pre-existing condition on that. So it would involve getting information from the individual and likely their attending physicians in terms of what was the nature of the pre-existing condition. Was it symptomatic or asymptomatic prior to the event? Were they able to work with that pre-existing condition? Did it have any impact on their occupational function up until the time that the event that happened at work? So that's the abbreviated answer. It can be a much longer discussion based on the fact scenarios.
Thanks, Sal. Another question for you, and then maybe afterwards I'll flip that to Jenny also for her examples of what she's experienced. There's been questions about stay-at-work best practices, and if you have any that you know of from WSIB, and then maybe afterwards Jenny can comment on any that she has seen or experienced at CTI. So maybe first, Sal, if you can comment on that.
Sure. Actually, I'm going to have Sue's with me here as Return to Work Director. I'm going to have her address the comment around stay-at-work.
Hi there. Thanks for the question. Very good question. So from a return to work perspective, when we have folks that are back in the workplace, I think, Jenny, you had touched on the notion of collaboration. And I think that's key here. There are many players that need to be at the table to ensure that we understand what some of the challenges might be, that we're accommodating as best we can, and that we continue to check in with the worker and as a team to make sure that we're on track and constantly re-gauging any opportunities and solutioning opportunities that might present. The other thing about stay-at-work cases, certainly from a WSIB return-to-work perspective, is one key factor in our approach to this is to keep in close contact with the treating physician. Oftentimes it could be a psychologist if we have a worker who is in any kind of treatment. So we keep in close contact in order to keep them apprised of the return to work itself, any milestones, any input that they might have. There may be case scenarios where we might even ask that the treating physician attend the workplace and that collaborative meeting in order to provide further input and guidance in terms of how to continue to proceed. But I do think that if there's one word that's key here, it's the collaborative approach.
Thanks very much. And Jenny, do you have any experience with stay-at-work policies or any best practices you'd like to share?
Well, I mean, I would just probably reiterate some of the points that have been brought up already. So definitely for us, we would be looking for the guidance from our return to work team. So they're on the benefits team and they would have access to the confidential information. So we're very clear about the division of responsibilities. So the leader and the local HR team may not have all the information, and we're looking for that guidance on what accommodations, what support do we need to provide to each individual. And I think, you know, I would say that what's very important to us is it's not a one-time communication or plan, but it's making sure we continue to connect. And if there are concerns, if we feel that someone may be at risk, we want to make sure that we're helping them so that there isn't that reoccurrence and they're able to get the support they need, that we've got the flexibility, but with the goal of keeping them, you know, moving forward.
Excellent. Thanks very much. And I'm just conscious of time. We are running low on time. There are tons of questions, and I apologize if we weren't able to get to your question. One kind of probably final question that I'll just pose to see who might want to comment on it is we've talked about, you know, return to work, stay at work for the employee. And how about other employees that may be working within their department or on their team in terms of communicating that accommodation to them and ensuring that they're kind of aware of what's going on, how they can support their colleague, but also the question was addressing any types of kind of complaints that other employees may feel if someone's receiving an accommodation that they may feel that they're getting preferential treatment. How do we kind of facilitate that knowledge transfer and allowing them to understand in a fair way kind of why that employee is being accommodated and how to kind of mitigate any of those feelings of unjust. Does anyone have any thoughts about that?
I can jump in on that if that's okay. So
yeah.
First and foremost, it's always critical to ensure that you maintain confidentiality. So while an employee, certain has an obligation to be forthcoming with respect to the prognosis around a medical condition with the employer, and in some cases it's not with the employer, as we know, in some cases it might be with a third party that employer has put in place essentially to deal with issues around illness. But I think confidentiality is something that's critical, and so you certainly don't want to put yourself in a position where the employee says that, my medical condition was unnecessarily shared with members of my team. And so in those circumstances, you must be careful. But I don't think from a productivity standpoint, there isn't anything wrong with an employer saying, look, there is a member on your team who's going to be away for such and such period of time or requires a certain accommodation. You just have to be very cognizant of confidentiality. That's what I would say.
Great, excellent. Does anyone else have any other thoughts on that question before we move on?
It's Jenny from CGI. I would say completely agree around the confidentiality, but this is also where we are talking to the individual, and I'm trying to think of an example of where we've modified their hours, modified their duties, and how do others on the team feel about that, what their understanding of why we've done that, and we're involving the individual to talk about how we will position it, and making sure we emphasize to everyone on the team around each of you have different needs, and we've got to be flexible. So we're very careful, but also wanting to make sure that we've got the individual as part of our plan.
Thanks very much, Jenny. And yeah, it's an interesting perspective on that balance between confidentiality, but also sharing enough information to kind of support colleagues. So thanks everyone for your questions and comments. It's been a great conversation, and we hope to continue this important conversation within your workplaces as we move forward on this. Just to note that today's webinar is part of a monthly series hosted the last Wednesday of every month. The next webinar in the series is scheduled for Wednesday, March 28th. More information about that will be posted on our website shortly, and registration will open next week for it. So we'll have some more information for you shortly on that. If you'd like to receive invitations from the Mental Health Commission to register for these events, please ensure to sign up for our newsletter or to send an email to webinar@mentalhealthcommission.ca, and that email will be listed on our last slide. So we hope you enjoyed today's webinar. At the end of the webinar, you'll be redirected to a brief evaluation survey that we asked you to take a few minutes to let us know how you felt about the webinar, as well as it allows you to suggest topics for future webinars. It helps us to continuously improve our webinar series. We'll also receive an email, again, with this link probably in the next few hours or so. And with that, I'd like to just close today's webinar. Before I close, just a reminder again that there is the slide deck to download that includes all the slides you saw today in the middle of your screen under the Files pod. You can download the PDF of that document right now, as well as there's been a fair amount of comments about the transcript of the chat. So if you do want some more information about that, you can email webinar@mentalhealthcommission.ca, and we can connect you with that document. So I'd like to close today's webinar and thank you all again for joining us. A big thank you to our guest speakers, Muniza, Sal, and Jenny. And thank you again to Leslie and Civic Action for your efforts to help put together today's event. We've included everyone's contact information on the final slide, which is in that download pod. So thank you also to my colleagues Hannah and Samantha, who are in the room with me today helping run this webinar. We hope to see you again on our next webinar, again on March 28th, and then we hope to help as you continue your conversations about psychological health and safety within the workplace. Thanks very much, everybody. Have a great afternoon.